Chair. Ms. Patterson, in Chairman Cicilline's introduction of you, he referenced your master's in public health, and so I want to ask a question about public health. Is there a different chemical composition for vaccines in white neighborhoods as opposed to non-white neighborhoods?
Yes, so my master's in public health does not mean that I have in any way had any access to be able to examine the different compositions of different vaccines that are provided in different neighborhoods. So,
do you have any basis to believe that the vaccines being administered in white neighborhoods versus non-white neighborhoods are different?
I don't have any basis to even begin to evaluate that question because, again, I don't have access to the data, samples, or anything like that.
What about the batching process? Is there something called a white batch of vaccines as opposed to a batch of vaccines that would be intended for non-white people?
Not that I've heard of.
Not that you've heard of. It's interesting, I found a tweet of yours from December 3rd, almost a year ago today, 2020, where you tweeted, "My COVID-19 vaccination plan, go to the whitest neighborhood I can find to make sure my dose comes from a white batch." How should we think about that tweet?
As the humor that it was intended, albeit kind of a dark humor in terms of the reality of the Tuskegee experiments and so forth in our community. And so there was a whole string of commentary that we had following from that about how it was a shame that we even have to think in these types of terms. So that's where—
Well, it would seemingly be more of a shame if we thought in these terms without a basis. And I understand people, put things on Twitter sometimes that are jokes. And I noted in response to your tweet, an account called Urban Dashboard replied, "You have a great sense of humor, but too painful to laugh at that joke." And then you replied, "I know, it's all too painful all day, every day. And as I said, I was barely joking because it's real!" Exclamation point.
Yes, the situation.
So is it real
real
that there's different, because you talked about a white batch, are white batches real?
As I said before, that the reference was putting in context this larger conversation about the differential access to affordable and quality healthcare in our communities.
No,
so it shouldn't be taken literally.
Oh, it shouldn't be taken literally. Okay, well, I guess my question is, you gave testimony today about your concern over the monopolistic sharing of information, about the criticality of the input of public interest groups, about how we have to stop the politicization of agency decisions. Do you think it damages public health, and do you think it damages the credibility of public interest groups like yours when you put out that your personal vaccination plan is to go to the whitest neighborhood so that you can ensure that your dose comes from the whitest batch?
Absolutely not. Because
you don't think that's dangerous? Is that misinformation? So how do I know if a batch is a white batch? If I wanted to follow your vaccination plan and I wanted one from the white batch too, where would I go?
Again, you're being facetious, and I've already responded to the question, and so I'm not going to respond to it again because there's not new information to provide.
Well, do you think that being facetious about race-based vaccination issues is dangerous? Because we have seen data that there are communities of color that are more skeptical of vaccines, and do you think that facetious comments like this are helpful?
So I think that they're important to raise a dialogue about why it is that people are more skeptical. I think it's important to raise the dialogue about how we can.
I only have a few moments left.
You're interrupting me.
Yeah, I'm interrupting you because I don't have a few seconds left.
No, you're asking me a question.
What's the most important part of the dialogue to understand from a white batch?
I think it's not really a legitimate seeking of information when you're breaking in when I'm actually responding to the question.
It's always legitimate to ask witnesses before the committee about their own
statements. But it's not legitimate to interrupt when someone is trying to answer the question.
Do you regret this tweet? Since it seems to be causing some consternation, do you regret having sent it?
No. because it's causing consternation with you. It caused an interesting and important dialogue that is not one that I'm the only one having, that a number of us are having
I
in
think
our
that
community.
sometimes that dialogue can metastasize into disinformation and can actually harm the people that you say you're here to help. My time's up.
No, it actually acknowledges the reality of what we all face.
But there's no reality of a white badge. That's just
The
something
time
you
of the
made up.
gentleman has expired. I now recognize the chairman of the full committee, Mr. Nadler.
Thank you. Professor Wagner, I'm particularly concerned that the Supreme Court may resurrect the non-delegation doctrine as a means of undoing the ability of agencies to implement statutes such as the Clean Air Act. Last month, the Supreme Court granted certiorari in West Virginia versus EPA, in which this question will arise. Could you explain what the non-delegation doctrine is and what the resurrection, what its resurrection would do to major legislation that Congress has passed in the last 80 years, and what the stakes are if lower courts begin applying this doctrine?
Yes, thank you, Chairman, for that question. The non-delegation doctrine is a doctrine the courts have pulled out of the Constitution, a few words that Congress shall make the laws, has a lawmaking power. So the courts have interpreted that as requiring Congress to make all laws without being able to delegate broad discretion and delegations to the agencies. As an aside, there's a lot of literature now, particularly two important articles that suggest there's no historic basis for even thinking there is such a doctrine in the Constitution. But putting that aside, over the last 200 years, the courts have only applied the non-delegation doctrine twice in 1935, in fact, I think because it has sort of a flimsy basis. So this is something we've worried about from time to time, but hasn't really come to the fore. So what has happened in Gundy is that we see some conservative justices in their dissent suggesting a whole new test for thinking about when Congress has delegated too much lawmaking power to the agencies. They say that statutes could be unconstitutional potentially if the agencies have more power than simply filling in the details or making fact-finding. So the minute agencies go beyond that, there's a threat. This could be catastrophic, in fact, for the administrative state if that kind of dissenting position became the majority position, because almost, I think, the last count I saw was 99% of Congress's statutes would essentially be at risk of being unconstitutional under that theory of the non-delegation doctrine. Hopefully the justices won't go that far, but if I were a member of Congress, I would be very concerned about this new non-delegation doctrine trend, because instead of Congress deciding what its lawmaking power is and how much it wants to delegate policy to agencies, it'll be the courts deciding what Congress's lawmaking power is.
Thank you. And in recent years, federal courts have begun to challenge longstanding precedent that in cases where Congress has not provided clear direction, courts generally defer to an agency's reasonable interpretation of a statute the agency administers. This is known as the Chevron deference. Chevron was a unanimous decision. After 30 years, why are courts now beginning to question agency deference? And if courts eliminate Chevron deference and decide cases under de novo review, how will that affect the ability of agencies to do the jobs Congress has delegated to them?
Thanks again for the question. I think the question is a really hard one. I unfortunately would probably cite to ideology as the shift in Chevron and the approach to Chevron. As the courts give less and less deference to agencies, we're going to see a lot more litigation against agencies. We're going to see rules come even slower, less protection of the public health, because it's just a feeding ground for lots of litigation. So as agencies lose deference, we will see a lot less protection of the public health than already is the case.
Thank you. Ms. Patterson, prior to an agency issuing a significant rule, the Office of Information and Regulatory Affairs reviews the rule. That review process often includes input from and meetings with affected industry stakeholders. In your experience, is the public, particularly frontline communities and vulnerable groups most likely to be affected by an agency's action, involved and represented during this review process? And if not, how is the absence of these stakeholders likely to affect the rules that agencies issue?
Thank you so much. Yeah, the absence of the stakeholder voice and engagement is impacted by the people making the decisions not having the full understanding of what the impacts are, and therefore the rulemaking not incorporating those very impacts. And so through not having the voice of communities that can speak to the impacts and also speak to what types of remedies actually work for them. And we all know the adage that the people closest to the problems are also people closest to the solutions. Without that input, then again, the rule is myopic. The rulemaking can be myopic and missing those critical voices and analysis. Thank you.
Thank you. I yield back.